Hello and welcome to the Disability Law Q&A with me, Martin Willemse. I'm a partner in Western Canada Disability Practice Leader at Samfiru Tumarkin LLP, where we handle disability claims, life insurance claims, and critical illness denials. We have offices throughout BC, Ontario, and Alberta, and handle claims throughout Canada, other than in Quebec and the territories. This is a session where I'm going to be responding to questions regarding disability claims, or long-term disability, short-term disability. So please send your questions to us via the social media platforms. As they come in, I'll address them. One of the things that I did want to address from the outset is often we get questions from prospective clients or for people making claims for LTD, long-term disability claims or short-term disability claims, whether their condition is deemed to be a disability. For example, somebody may write to us and say, is fibromyalgia a disability? Or is ankylosing spondylitis a disability? And one that we often see is a migraine disorder a disability? The big thing when you look at a disability claim is not so much the diagnosis itself. Yes, of course, it is important, but it is the functional impairment that results from the condition itself. The disability is assessed based on the language of the disability policy. Most policies will have language similar to what I'm going to say now. It would be total disability means that you have an illness or an injury or a condition that prevents you from performing the essential duties of your own occupation. And then later on, there may be a change of definition. But the question there is a condition that prevents you from performing the essential duties, be it your own occupation or another occupation. So an illness could be anything that has been diagnosed. Sometimes the doctors struggle to find a diagnosis. They know that there is an illness, but the person is struggling and is undergoing further investigations. Then the question is, should I be submitting a claim now? Can I submit a claim if there is no diagnosis yet? Or if it is a diagnosis, would this diagnosis count as a disability? So remember what I said when we speak about functional impairment. So when you submit a claim for disability benefits, your doctor will have completed something called an attending physician statement. In that physician statement, the doctor will outline what the diagnosis or diagnoses are, and then most importantly, address what the functional restrictions and limitations are. I've often said in this platform and others, if you have, for example, a mental health disorder and the doctor completes the form saying that, let's say you have depression, that you have depression and therefore you cannot work, your claim will be denied. It is the functional impairment that is key to the assessment and the qualification as to whether a person is disabled within the meaning of a disability policy. If you have a migraine disorder and you are triggered by screens or noise or light or smells, aura, and you have to go to your room to be in a dark place, you have migraines that are coming on. The pre-migraine phase is disabling. The post-migraine phase, once you've had migraines, you may feel extreme fatigue, there may be confusion, there may be brain fog, etc. All of those are the things that are considered, the restrictions, the limitations, the symptoms, to quantify and qualify whether you are unable to perform the essential duties of your occupation. So when we get the questions whether this condition or that condition is deemed to be a disability, take a different approach. What are the restrictions and limitations that have resulted from that diagnosis? What is the functional impairment? And do not I've heard people say to me, but the insurance company or the case manager has told me that fibromyalgia is not a disability. That is absolute nonsense, if that is what has indeed occurred. Each condition may have restrictions and limitations. It is the severity of the functional impairment that is key in the assessment of disability. So if you do find that you have a condition that is impacting your ability to perform the essential duties of your occupation, it is extremely important to see your doctors on a regular basis so that your doctor can record in his or her notes, in your clinical chart, why you are visiting the doctor, and what your restrictions and limitations as you report them are, so that the doctor, when they do support that you file a claim for disability, can be in an informed position to complete the attending physician statement. And if there were to be a denial, that the doctor could support their own position in a letter to the insurer as to why it is that you are unable to perform those duties. Now, of course, we offer free consultations. So if there is a denial, for whatever reason, you are welcome to contact us. As I said, we offer free consultations, and we can discuss with you your claim, your personal circumstances. We can review the denial letter with you. If you have the policy, we can review the policy with you as well, and we can then discuss with you what your options are, so that you at your end can make an informed decision as to how to navigate the denial. At our end, when we're retained, we focus on getting our clients the best possible compensation under the terms of the policy, so that our clients can deal with their conditions, follow through with recommended treatment advice, and focus on improvement without having to communicate with the insurance company. So again, if your claim is denied, or if you have questions regarding your claim while you're still on claim, you're welcome to contact us, and our team will put you in touch with one of our lawyers. As you can see on the screen, if you've got questions, you can go to help@disabilityrights.ca. So our first question comes from YouTube, from Clint. I've just applied for LTD and it will be 3 weeks on this Thursday since. Should I be calling them to find out what is happening with my claim, or should I wait until they call me or send me an answer in the mail? Many people ask me, how long does an insurance company have to make a decision? I always believe that the squeaky wheel will get the best results, because sometimes they do not contact you immediately. So there's nothing prohibiting you or preventing you, or I don't see that there's any concern with you contacting the insurance company if the insurance company is not responding with you. If you find that it has taken some time and you have not received any response, and you contact the case manager and they're not responding, contact the intake team or the reception, find out who that case manager is, the supervisor, and continue to contact them until you get a response. These policies are deemed to be good faith policies and peace of mind policies, which means that when you have a disability policy, it is supposed to provide you peace of mind when you're unable to work and dealing with an illness, which means that the insurance company has a duty of good faith when dealing with you and when assessing your claim. Having a person wait for a decision for months at times, in my mind, would not be abiding by the duty of good faith. So if there is a delay, contact the insurer, contact the supervisors until you get a response. There's a question from Falgun Patel. I'm seeking your expert opinion on a sensitive matter involving a workplace injury claim. Suppose an employee reports being injured at work and files a claim accordingly to WSIB. However, the employer has clear CCTV footage showing that the injury occurred before the employee's shift began outside of work hours on premises. In such a scenario, can the employer consider this a breach of trust or false representation? Would this justify termination for cause under Ontario employment law? What are the legal risks of considerations in proceeding with termination based on this evidence? Thank you. Falcon, firstly, we cannot give you expert opinion on this. This is a free consultation or free service where we provide some information regarding disability claims. Your questions, as I read them, are very much focused on employment matters and WSIB matters, which I think would be best posed towards an employment lawyer. What we're doing today is having a discussion regarding disability claims under disability policies. So I do recommend that you can contact our firm if you want to have a discussion regarding termination issues, because we do have employment lawyers as well. And I do believe on Thursday of this week, there will be an employment law Q&A as well. And that would be, let me give you the time, so that would be July 24th at 2 p.m. Eastern Standard Time. Bill asks, is it normal for your LTD coverage to change in an amount after 2 years? Okay. What usually happens after 2 years under a disability policy, and this is not each policy, this is a general statement, most policies will have a change of definition. What that means is that the insurance company will have in the policy two definitions. The first definition usually would be that you would have to prove that you are unable to perform the duties of your own occupation. So that's for the 2 year timeline. After that 2 year timeline, the definition itself changes to you have to prove that you cannot perform the duties of any other occupation for which you do have the transferable skills. And that would pay to you a certain amount of income. The LTD amount itself does not change. The only way that that would change is if you're, for example, if there is an offset that is applicable. An offset would be something like CPP disability benefits. If your CPP disability is approved, it is deducted usually under the terms of the policy. Some policies will provide that if you do not apply for CPP disability and you are eligible for those payments, but you refuse to apply, that the insurance company can estimate the CPP disability benefit amount and deduct it from your LTD benefit. But your question, is it normal for LTD coverage to change in amount after 2 years? No, it's not normal. We would want to review the policy. So unless the insurance company has advised you that the assessment for disability has changed, which means that some policies will provide in the any occupation phase that you have to prove that you are unable to earn a certain amount of income. So the income level that is assessed to determine whether you qualify for benefits, that may change. But the benefit amount itself does not change. I hope that answers your question. If you've got any further questions on that, if you want to have clarification, please contact us and we can put you in touch with one of our lawyers. Question on Facebook from Esmeralda. I'm dealing with an anxiety disorder. The insurance company the insurance company does not have provided any guidance about documenting my limitations or how to access accommodations at work. What do you suggest I have my doctor provide that I can have my claim approved? So, if you're dealing with an anxiety disorder, this goes back to when I started speaking this morning. What do I suggest you submit in support of a claim? Your doctor is going to be completing the attending physician statement. In that statement, the doctor is going to have to respond to various questions. It's a form that is completed. One of the questions will be, what is the primary diagnosis? If the primary diagnosis is anxiety disorder, the doctor will note that. If there are other conditions noted as well, like secondary diagnoses, the doctor can complete those. Then there will be objective symptoms, restrictions, limitations, questions like that. Dealing with an anxiety disorder, how does that impact your ability to perform the duties of your occupation? So, the doctor will have to detail what those restrictions and limitations are. With an anxiety disorder, it may be that you have panic attacks. It may be that you are unable to deal with people. You may have issues with focus, concentration, and memory. If it is coupled with the depression disorder, you may have issues with your sleep. Poor sleep that may interrupt sleep, which may lead to fatigue. It may lead to poor motivation. It may lead to inability to multitask, inability to comprehend new information. Sometimes with an anxiety disorder, the person may be will have issues with leaving the house, dealing with the public. Consider what your occupational duties are. If you deal with the public, or if you have to deal with, or if you have to multitask, how does your condition impact your ability to perform those duties? That's what they would be looking at. They would also be looking at what treatment you are receiving. When you have a disability claim, you have to detail what the treatment is. Under the terms of the policy, you would have to be under the appropriate treatment of a physician and be receiving appropriate treatment for your condition. If you have an anxiety disorder and you're simply staying at home but not doing any treatment, that may lead to denial as well. So with anxiety disorder, you may be doing counseling. You may be seeing a therapist or a counselor or a registered psychologist. And you may have been given medication. You may be taking Ativan or some other medication to manage your anxiety symptoms. That would have to be detailed as well. If this has been going on for some period of time and there has been no improvement, your doctor may want to have you referred to a psychiatrist. If that is the case, have the doctor note that. I have referred my patient to a psychiatrist. In the meantime, my patient is taking these medications. There has been an increase in the dosage. She's doing counseling, etc. Those are all the things that you should submit in support of a claim. After these cases are denied, and when I have discussions with people about their denials, none of this information was communicated to the insurance company, which then, not surprisingly, led to the denial itself. So, in order to give yourself the best opportunity to get the claim approved, it is necessary to submit as much supportive information as possible, which also may mean that if you're seeing a counselor or a therapist or a psychiatrist, you may want to provide letters from them as well in support of your claim. I hope that was helpful. Okay, so question on YouTube from B. I'm on LTD with my company since January 23 of 2022. I received a letter in the mail dated July 15, 2025. The letter is asking a written response confirming whether I expect to return to work in the foreseeable future. And if so, is there an estimated time of return? They've given me a deadline of July 31, 2025 to respond. I have stage 5 kidney disease and I'm on dialysis and the condition is deteriorating. I will not be returning indefinitely. Can my company ask these questions? And if so, I respond without seeking legal advice. Can my insurer cut me off because of this? Okay, so an insurance company would not necessarily send you that type of letter. What I'm reading through when I look at this, I think it is the employer who has sent this letter to you. And it might be that the employer is asking these questions to consider whether if you're unable to return to work at all, that they may be considering terminating your employment based on frustration of contract. Now, I cannot speak about employment issues because I'm not an employment lawyer, but that's what that letter, or your email at least, that's what that tells me. Can the insurance company deny your claim based on that? If your condition is deteriorating and you have an objective condition here, you've been away from work since January to the 23rd of 2022, which tells me that if your policy has a 2-year own occupation period and then you change it to in the any occupation phase, that the insurance company is likely accepting that you are disabled from working in any occupation. Will they terminate your disability benefits because the employer may be terminating your employment? That's not how this works. It should not be the case that an LTD insurer would terminate the claim because the employer may terminate the employment. Your claim vested when you had coverage. In other words, while you were still working. So that claim is in place. And the only way for the insurance company to deny your claim or to terminate it would be if the insurance company decides that you are no longer meeting the definition of total disability, or if you return to work, or for whatever other reason they may find. It should not be an automatic denial because the employer has terminated your employment. Those two are separate things. But if that were to happen, very welcome to contact us and we could look into it further, get more information from you, and discuss with you what your options would be. As again on the screen, you can go to disabilityrights.ca for any further information. Question from Lindsay. My insurer has been pushing me to start a return to work program and have already set up a time for me to speak with someone about this. This is in contradiction to my doctor's recommendations. What can I say to them to stop them from doing this? This is a difficult area to navigate because the insurance company may internally have some information which they believe would put you in a position that could have you return to work. If your doctor disagrees with this, have your doctor put in writing why you are unable to engage in a graduated return to work program. It depends on what that discussion is about. Quite often, insurance companies will retain, or they may even employ in-house, a rehab consultant. That rehab consultant may speak to you to try and gauge whether there is an opportunity to put you in a rehab program or to support you the language that they would use, to have you return to work. In other words, even on a graduated basis. So when that happens, have your doctor or see your doctor extremely regularly so that your doctor, if the doctor disagrees with the program that they want to propose to you, have your doctor put in writing why that is not appropriate, why an early return to work would be ill-advised. It would sometimes be the case that the doctor would feel that if you did engage in the program, the doctor may support it. If it is supportive treatment on a gradual basis, that may assist you becoming work ready. But if the doctor does not agree, the doctor may say that by engaging in the treatment or by pushing you to return to work early, that any gains that you may have had will be eroded, which may result in a relapse of your condition, which ultimately may result in a prolonged absence from work, where you were making some improvements prior to this program, which would have allowed you to return to work earlier, and they simply kept you on claim for a certain period of time into the future. Now, I don't know exactly what your circumstances are, but in a case where a doctor disagrees with what the insurance company says, I would always recommend that the doctor put in writing why they disagree, that you are receiving appropriate treatment, that you're attending, that you're motivated to improve, and that any early return to work would have a negative consequence. If the insurance company then still denies you on that basis, please contact us, or you can contact us now as well. Speak to one of our lawyers so we can get further information, probably give you better advice. Again, on the screen, go to disabilityrights.ca for any further information. Timble says, I have been dealing with CPTSD, which is complex post-traumatic stress disorder, for the last 2 years. Recently, a traumatic experience at work has set me back a lot, and I am off on leave. My insurer denied my claim, saying it was pre-existing. What is the likelihood that I could get this changed, or are they right in this because I was treated for it before? This question is a question that or something similar to this, that we all deal with at our firm on a regular basis. Pre-existing conditions are tricky. What I mean by that is, with a pre-existing condition, when you submit a claim, the term pre-existing condition may not mean what we think it means in terms of our everyday life, in everyday language. When you have a policy, which is what we have here, each policy will have contractual language detailing the definition for pre-existing conditions. I'll use an example. If you have had anxiety throughout your life, and you have been treated for it at times and other times you have not, but it's an ongoing thing. You start work with an employer on January the 1st. On October the 1st of that same year, you go off work. Because of anxiety, the vast majority of these policies will provide that if you go off work within the first year of having coverage, then the insurance company can investigate whether your disability is directly or indirectly related to a pre-existing condition. And if so, they can deny your claim. Now, this is a general statement because each policy has its own definition. Going back to an example, it may be that you did receive treatment for anxiety, but there was a certain period of time where you did not receive treatment, even though it is a pre-existing condition. The policy may provide that because the pre-existing condition exclusion investigation was triggered by the fact that you went off work within the first year. Now they're going to look at what the language says. The language may be that if you receive treatment for a condition during the first 3 months or before the first 3 months during the period that you had coverage. In other words, the first 3 months that your coverage started, or it may be the 3 months before your coverage started. If you receive treatment for a condition that is directly or indirectly related to your disability, then the insurance company can deny your claim. Now, treatment or medical care may be a definition as well, may be defined, which may mean that if you consulted with a doctor, or if you were referred to a specialist, or if you took prescription medication. Now let's use this example again. You start with them on January 1st, your coverage kicks in on that day, you go off work on October the 1st, So it's within the first year. Now they're going to investigate whether during the first 3 months prior to your coverage, did you receive treatment for any condition that is related to your disability? If you received treatment for your anxiety disorder in the previous year, but not in those 3 months, it's not pre-existing. Even though logically we would think it is a pre-existing condition, if you did not receive treatment during the defined period, then it is not pre-existing. So in these cases, it is crucial that when you have a pre-existing condition exclusion, or your claim was denied because of a pre-existing condition, that you do seek legal advice so that the lawyer can review the policy, look at the termination or the pre-existing language in your policy, look at the medical records, the denial letter itself, to see whether the condition is in fact a pre-existing condition, because there may be arguments that it is not a pre-existing condition, that it is not directly related. I've seen many cases like this. I have cases in my caseload, so do all the other lawyers at our firm, because there may be an argument to be made that the pre-existing condition that the insurance company says is related to your disability may not be related. And maybe in cases where you may have had depression that was being treated, but your disability is now complex PTSD, like in your case. It really depends on the factual circumstances. So do not simply accept that the insurance company is correct. They may very well not be correct. And if there's an arguable claim, we can discuss with you what your options are. One more question. This comes through YouTube from Tinkerbell Rangela. Interesting name. My insurer has set me up with several medical professionals for vocational rehabilitation. Is it normal that my vocational rehabilitation consultant is changed every 2 months or so? Is it normal? I don't know. What often happens is, I've seen cases, and I've seen so many cases, where they may have a vocational rehabilitation person who may go off work, or there may be somebody new in place, or the person may go on mat leave, or they may move to a different company. It really just depends on the factual circumstances. So is it normal? Not necessarily. Does it happen? Yes, it does. Like with any employer, some people come and go. As long as it doesn't impact your actual disability claim itself, shouldn't. But if the insurance company were to deny your claim, or if you've got questions regarding the adjudication process itself, you're very welcome to contact us. With that, we get to the end of today's session. Thank you for tuning in. More questions, you want more information, you can go to disabilityrights.ca. Our next session will be, let me tell you, there's another disability law Q&A tomorrow, July the 23rd at 1 a.m. That cannot be correct, 1 p.m. Eastern Standard Time with Tumarkin, which will be 10 a.m. Pacific Standard Time. And our next employment law live stream is on Thursday, July the 24th at 2 p.m. Eastern Standard Time with Jeremy Herman. Thank you, and I hope everybody has a good week.